Hello, it's Philip Taylor speaking from Richmond Green Chambers in London. Looking at a really interesting book which has come to us here at Chambers. It's been written by Stephen Mason, who will be known to many of you for other work that he's produced. This comes from PP Publishing, Peer Press I think Publishing is the name of the company who produced it. Mason has produced quite a lot of books on electronic evidence and various other areas of that electronic information storage and so forth. And he's gone from there and looked specifically at a worrying area for some of us on what is called email, social media and the internet at work. And he's produced this book. It's actually a concise guide to compliance with the law. Now, this is the book itself. Email, social media and the internet at work, Stephen Mason. That's the front. It's a concise guide to the compliance with the law. Now, I'm not quite sure what the edition is because it says here that this is the 2014 edition. I'll just show you the front of it there. It actually says, it's got the word 7th edition mentioned there. It calls it other editions by other people, but I'm not quite sure exactly which number it is, but I'm calling it the 7th edition. There are 12 chapters and 2 appendices. You can see the list there. Then a lot of cases covering wide jurisdictions, lots of legislation as well, and then we get into the book itself, networked communications in context. Now, for some people this is going to be very confusing because you probably won't know some of the words that are being used. The index is quite short, which is at the back. They do have a little language of their own within social media. There are some appendices, sample email and policies, which you might have for your business. And in fact, there are further examples of misuse of these communications, which is the big problem in business at the moment. Then we have checklists and various other things at the back, for instance, dealing with policy itself, defamation, use of various viruses and so forth and so on. That's the checklist actually right at the back of the book itself. I've been very impressed with the book. There are no footnotes or anything, but there are some useful cases. For instance, there's the case of Cass and Gillies there, which is quite interesting, where people sometimes overreact. Obviously, human rights law comes into it as well. It's a very interesting book for our times. It's one that I think everybody who's running a firm or a chambers should have, because they should know where the line must be drawn between what you do privately and what you do in the business world. The problem is they both overlap, and they always have done in the past. We are beginning to see now, certainly in America, big changes where they're delineating between what is private and what is private personal use, in other words, and what is for your business and what you do. Now, it's difficult when you are self-employed to try and have that delineation in the same way, but when you're actually in a main firm, you must have that, and therefore you've got to have a policy, and any chambers will have a policy, and certainly I would think the Bar Standards Board will be encouraging us, as will be the Solicitors Regulatory Authority, the SRA, to make sure we have proper systems in place to delineate between the two. Now, my wife Elizabeth and I looked at this book, and I say we came up with an interesting title for it. For our review, a practical explanation for communicating in the virtual world, now in a new edition. And I'm going to call it the virtual world because that really is what in my view, what we're really talking about. If that is of some understanding to people listening to this review, because we use different words and they probably mean the same thing in some respects, but I'm going to use the term the virtual world. Barrister Stephen Mason is probably, as I say, very well known to many readers for his excellent statements on electronic evidence and electronic signatures in law, both of which I've reviewed, and they're mentioned actually at the front of this book. And they've added greatly to our understanding of how the virtual world operates legally and where the actual barriers are. Now, we feel that this updated work entitled Email, Social Media and the Internet at Work, is of such current importance that no firm or set of chambers should really be without it. The changes to the issues relating to the use of the computer in the world of work are of profound significance, we think, halfway into the second decade of the 21st century. All readers will know of the massive shift in the way we do our business today. It's totally different from when I was called to the bar, totally different way entirely. By necessity, this has created a new area of virtual world law, as I'm calling it. And as I say, if we can call it that, because of the obligations and the responsibilities we all now have to face up to in order to comply with the law. Obviously, it overlaps with basic substantive law areas like tort, defamation, and so forth. Possibly employment law, contract law, and so forth. Human rights come into it as well. The question is, do we actually know what this virtual world law really is? And because we're setting out on a new era, if you like, and a new adventure with what we've actually got to deal with. And as Mason says, the content of this work is deliberately general in nature. And I thank him for that because he makes it understandable. Because his aim is to make this developing area of law and precedent understandable to those setting up a policy, policing it, or defending themselves if they get into the windy side of some problems. Of considerable interest are the problems which have occurred very recently with the use of the computer in the workplace. One fundamental example quoted will be of universal importance to both managers and workers, if we can use such outdated terms in the computer age. And it is this leading statement that he makes, and I'm going to quote it. Some people do not adjust their behaviour when using such technologies, causing themselves, their friends and families and their employers embarrassment. Others use the technology to steal, commit fraud, bully and continue with unpleasant and illegal activities, and do so when using the corporate infrastructure. And that, I'm sure, we all know what he's alluding to and what I'm alluding to here. What Mason does here then is to answer these questions as fully as possible and give both guidance and support to those who are frankly both bemused and possibly terrified about some of the implications of virtual world law. There are pragmatic step-by-step points and policies throughout the 12 chapters to provide assistance to those who have to confront this minefield as we traverse social media and its effect on our business and personal lives. The practical tips and the case law are also well explained and helpful. I'd like to conclude, because I think this is a very important book, I would conclude on this point, and that is this book is, I think, a necessary purchase for any business library in your firm or set of chambers, because there will be no retreat from the expansion of the virtual world in the coming years as a new generation of workers and managers come to grips with the way people connect with each other in the early 21st century, where they have their conversations and effectively the way we now do our business. So thank you, Stephen Mason and Peer Practice Publishing, for a massive piece of assistance to what is so confusing to so many people. And unfortunately, social media is, with people who are effectively children, a bit of a problem because they are not actually behaving as responsibly as they can. So you need this book, and you need the statements concerning things like policy, which will set your business quite clearly on a path where you know where the barriers are about what you can and can't do. Because the behaviour of some people on Twitter in particular is absolutely appalling, and it's something that cannot be dealt with until we have to have a bit of self-policing. There has to be a bit of restraint, and there has to be just a bit of sense. Unfortunately, there isn't as much as we would like around at the moment about that. Let me just talk about breach of confidential information, because that's really the other part of the law where it comes in. Where you're breaching information by, at the workplace, giving information, you're looking at some form of commercial espionage that could be taking place. So you've got to be very well aware of it. I think this is an excellent book from Stephen, and I'm very grateful that he's produced a new edition. Thank you to him. Thank you to the publishers. Do read it. It's easy to read, and it makes a lot of sense. I think I'd make it compulsory reading for some people. who just cannot stop sending silly emails and tweets, or whatever they are. Thank you to all concerned anyway. Bye-bye.